So, good afternoon, everyone. I think we're just about ready. I'd like to welcome you to the final of the 2019 FDI moot here in Miami. I know it's been a very long road for all of you, and there's still a little bit more to go for two teams, Team Vicuña, who will be the claimant, and Team Palmer, who will be the respondent. We have a celebrity tribunal to judge this final match, and I'm going to let Sandra introduce them because they're all very closely affiliated with the University of Miami, so that's her achievement.
Thank you, Chris. Hello, everybody. Welcome to the final round of the FDI moot in Miami. It's been our pleasure to host you, and I hope you've all had a wonderful time. It's my distinct pleasure right now to introduce to you our esteemed judges for the final round. Chairing the tribunal, we have Carolyn Lamb, who's a partner with White & Case in Washington, D.C. in the arbitration group, where she serves as lead counsel in complex international arbitration and related litigation proceedings representing international corporations and sovereign governments. She also is an alumna of our law school and serves as the distinguished faculty chair of our White & Case International Arbitration LLM program. And of course, she also teaches in the program a course on what else investment arbitration. To her right, we have Cristina Cardenas, who is a partner in the Miami office of Reed Smith. She specializes in international arbitration and complex litigation cases all through the Americas. She's also an alumna of our law school, and she's also a member of our adjunct faculty. She teaches a course on international arbitration in Latin America and the Caribbean. And then last but not least, we have Luis O'Naughton. He's a partner with the Miami office of Hughes Hubbard. He has over 30 years of experience in international arbitration and complex litigation. He serves as counsel and arbitrator throughout the US, the Americas, and Europe. And he is also a member of our adjunct faculty for the White & Case Arbitration LLM program, where he teaches a course on the Federal Arbitration Act. And I should mention that he is the incoming president of the Miami International Arbitration Society.
Sign up.
Now with that, I'm going to hand it over to the teams, and looking forward to an exciting finale.
Good afternoon. The tribunal is pleased to be here and hear your arguments. I believe Claimant has the floor.
Madam Arbitrator, Respondent will start on procedural issues.
It's your motion. Please.
Before you start, are you reserving any time for rebuttal?
Yes, members of the tribunal, we reserve 1 minute for rebuttal.
So it would be 19 minutes for your principal presentation and then a minute for rebuttal.
Yes.
And for claimants?
We'll reserve 19 minutes for both of us and 1 minute for rebuttal.
Perfect. I will be, I guess, the official timekeep. I'm not sure I'm official. And I will try, as you're getting close to the end, I'll try to mention you're coming close to your time. Come on.
Madam President, Honorable Tribunal, esteemed opposing counsel, good afternoon. My name is Daria Soshnikova, and together with my co-counsel, Nika Vartanova, we represent the Republic of Tyria, respondent in the present proceedings. I will speak first, and I will address the procedural issues of the present case. I will accordingly make 3 main points. First, that this tribunal shall grant provisional measures requested by respondent. Second, that this tribunal does not have jurisdiction over the present dispute because respondent denounced exit convention. And finally, that this tribunal cannot consider submitted claims on a multi-party basis. Coming to the issue of provisional measures, members of the tribunal, respondent respectfully advise this tribunal to order claimants to refrain from taking any steps which might aggravate the present dispute or exacerbate respondent's position in it, and more specifically to abstain from publications of propaganda against the respondent, as well as from the outside from presenting the case selectively outside the present proceedings. And respondents' request for provisional measures in the present case complied with the legal test provided in Article 47 of the Exit Convention and supplemented by Exit Arbitration Rule 39. Because firstly, claimant's media campaign aggravated the present dispute, and secondly, the requested measures are urgent, necessary, and proportionate. And coming to the issue of aggravation of the present dispute, members of the tribunal, to clarify, we do not contest that under the Exit Convention there is no general obligation of confidentiality, and thus parties are free to generally discuss their case in public. However, as EDF versus Romania, Bywater versus Tanzania, and United Utilities versus Estonia tribunals demonstrated, this right indeed has its limitations, because parties cannot use their right to general publication, and more specifically, they cannot resort to the media in order to use it as a tool to antagonize the dispute or unduly pressure the other party in the proceedings. And accordingly, the party should avoid the so-called trial by media. And these very obligations was violated by claimants in the present case. And opposing counsel will most likely deny its responsibility for any actions except for the publication of the request for arbitration in Global Herald in 2018, in October 2018. However, the circumstances of the present case demonstrates the causal link between claimant's actions and the media campaign instigated against respondent. And to demonstrate that, I would like to invite you to the page 53 of Uncontested Facts. Paragraph 25. And it is stated there in line 1646, and I quote, "Arbitration, however, was regarded by claimants as too slow to restore their rights." End of quote. And accordingly, they engaged the public relations firm and resorted to other unofficial measures so as to, and I quote, "expedite bilateral resolution of the disagreement with Tyria." End of quote. And whereas the present proceedings were initiated in the end of June, namely on 29th of June 2018, where a request for arbitration was filed, the very first publication was published already in July 2018, and the list of these articles, at least of the articles which appeared in 2018, is presented on pages 36-37 in the request for provisional measures. And all these articles employ highly judgmental wording, and they create the one-sided picture of events within a area because they overemphasize the effects of the blockings on the freedom of speech within the state. However, they do not address the real public aim behind this measure, and namely the fact that the respondent was forced to block the claimant's websites due to the severe ethnic conflicts and human casualties within the state. And accordingly...
Can I interrupt you here? Can you explain to me how it's aggravated this dispute before us? You know, I don't read the Tribune, and so I'm just see what the memorials say. So how is it aggravated the dispute and affected your client?
Mr. Arbitrator, as Bywater versus Tanzania Tribunal demonstrated, the right to the non-aggravation of the dispute includes various aspects. For instance, an obligation not to undermine the relationship of trust and confidence between the parties, as well as an obligation not to instigate so-called trial by the media, and also an obligation not to exert unduly pressure on the other party. And accordingly, we submit that the fact that the respondent was unduly pressured by this large media campaign, which actually was also supported by the publication of the request for arbitration, as well as the witness statement of Ms. Palante, is sufficient to constitute an aggravation of the dispute and subsequently justify the grant of the provisional measures.
Councilor, if I can just ask a follow-up question. I mean, you noted that there's no general right of confidentiality. Where do you draw the line in terms of, are there any documents that can be disclosed? What can be disclosed regarding this arbitration?
Madam Arbitrator, of course, this assessment should be made on a case-by-case basis. However, as demonstrated by United Utilities versus Estonia Tribunal, at least arbitration documents, the disclosure of arbitration documents, which are parties' written submissions and also witness statements, as we have in the present case, these disclosures are not covered by the right to the general discussions of the present case. And subsequently, the fact that claimants accepted their responsibility for the request for arbitration is sufficient to grant provisional measures. And as for the requirements of the necessity and urgency in the present case, to assess them, we invite this tribunal to uphold the approach elaborated in EDF versus Romania case, where the tribunal stated that minimizing of any external pressure of the other party is a mission of the tribunal, and there is no need for an actual or imminent harm in order for this mission to be carried forward. And accordingly, in the present case, the circumstances indeed justify the grant of provisional measures. And as
Can I ask, were there any other laws that would have precluded the disclosure of that kind of information? Privacy laws, because witness names, addresses, etc. were disclosed, or anything?
Madam President, could I please ask you to clarify the question?
The question, national laws, were there any national laws that would have precluded the disclosure of the materials they disclosed?
No, Madam President, in the Republic of Korea there is no national law which might preclude such a disclosure. And as for the last requirement of proportionality, here we also invite the tribunal to apply the approach of United Utilities versus Estonia case, where the tribunal also assessed the aggressive media campaign, and actually in that case, claimants also denied their responsibility for an instigation of such media campaign. However, the tribunal decided to grant provisional measures in order not to aggravate the dispute, and stated that in that circumstances, the requested measures were both reasonable and proportionate. And proceeding with my second submission, which is the denunciation of the Exit Convention, Respondent submits that this tribunal does not have jurisdiction over the present dispute because Respondent revoked its consent to the exit arbitration on 5 January 2018, when the notice of denunciation was submitted, whereas claimants initiated the present proceedings 5 months later, only on 29th of June 2018. Members of the tribunal, under Article 54 of the Vienna Convention on the Law of the Treaties, the international treaty can be withdrawn by a state in conformity with the terms of this treaty. And in the Exit Convention, the denunciation is regulated by 2 articles, namely Articles 71 and 72 of the Exit Convention. And there is a division of labor between these 2 articles, because Article 71 is addressed to the denouncing state as a contracting state of the Exit Convention, and it establishes 2 general rules. First, it provides that each contracting state may denounce the Exit Convention. And second, it also states that the denunciation shall take effect 6 months after the notice of denunciation is submitted. And this very additional 6 months period covers all the rights and obligations of a contracting state of the Exit Convention, which are provided in Chapter 1 of the Exit Convention, and these are namely an obligation, a right to participate in administrative council, an obligation to accord immunities and privileges to the center within the territory of the denouncing state, and an obligation to finance the center. However, subsequent Article 72 of the Exit Convention regulates the obligations which arise out of the consent to jurisdiction, as it states that notice pursuant to Articles 70 or 71 does not affect the obligations which arise out of the consent to jurisdiction expressed before the notice of denunciation was submitted. And thus the purpose of this Article 72 is to support the general rule of the non-irrevocability of the mutual consent, which is provided in Article 25 of the Exit Convention, and actually to ensure that all the arbitrations which were initiated by mutual consent of both disputing parties before the denunciation was submitted, the notice of denunciation was submitted, would be concluded to the reasonable result in disregard of the denunciation. And accordingly, we submit that for Article 72 of the Exit Convention, the mutual consent of both parties is required. And this approach is also supported by the preparatory works to the Exit Convention, to which this tribunal can resort to as a supplementary means of the treaty interpretation under Article 32 on the Vienna Convention, the Law of Treaties. And during the drafting...
But you would admit that that's the minority view, right? That would be the minority view.
Mr. Arbitrator, indeed, there is only one case where this approach was upheld by the tribunal, namely it was the case of the Fábrica de Vidros versus Venezuela. However, this is the most recent case on denunciation, and accordingly it analyzed the practice of previous investment tribunals, for instance, of Blue Bank versus Venezuela case, to which opposing counsel may rely upon. And in that case, the tribunal stated that the previous decisions lack thorough analysis of correlation between these two articles, Article 71 and Article 72 of the Exit Convention. However, Fábrica de Vidros versus Venezuela tribunal based its argumentation on the application, on the interpretation of these articles in accordance with both Article 31 of the Vienna Convention and subsequently by Article 32 of the Vienna Convention of Law of Treaties, as Fábrica de Vidros tribunal also relied upon the preparatory works to the Exit Convention. And accordingly, we submit that this approach is the valid one for this tribunal to be guided when decided the present case.
But wouldn't the notice and the request for arbitration in the 6-month period have vested the rights such that you were within the period noted under Article 71?
No, Madam President, because it is our submission that this additional 6 months period is not applicable to the acceptance of the consent, and accordingly, the denunciation would not affect the consent of respondent only if investors perfected it before 5 January 2018. And opposing counsel may argue that such a strict interpretation would preclude claimants from consideration of their dispute as provided in Terina Vanda and Aliki-Athina BATs. However, we submit that in the present case, both the interests and the right of respondent state for an orderly exit from an exit convention is balanced with the expectations of investors connected to the initiation of proceedings. Because Terina Vanda and Aliki-Athina BAT both provides for a fallback mechanism in Article 9.2. Namely, they provide that as long as the Republic of Tyria has not become a contracting state of the exit convention, the dispute can be resorted to arbitration under the additional exit facility rules. And opposing counsel may argue that this provision is limited only to the interim period before the exit convention is entered by the Republic of Tyria. However, we submit here that this period covers all the instances when the Republic of Tyria is not a contracting state of the exit convention, because here we can also refer to the supplementary means of the treaty interpretation, however, not to the preparatory works, but to the circumstances of this treaty conclusion. And if we refer to this instrument, we can say that the Republic of Tyria concluded the Aliki-Athina BAT when it was already a party to the exit convention. And subsequently, the interpretation which might be proposed by opposing counsel is not the valid one because it contradicts the circumstances of the treaty conclusion. And accordingly, the approach proposed by respondent state is also complies with the interests of claimants, since even though under the additional facilities rules there is no an enforcement mechanism, all three states, Tyria, Athina, and Navanda, are parties to the New York Convention in 1958, and thus the awards could be enforced. Members of the tribunal, now turning to my final submission.
Just so you know, about a little bit over 15 minutes have passed, so you have about another 4 minutes.
Okay, thank you. Here we submit that this tribunal cannot consider claimants' claims on a multi-party basis. And members of the tribunal, to clarify, we do not dispute that general consent of respondent to the exit arbitration also does cover the multi-party arbitration. However, the very purpose of multi-party proceedings is to promote the efficient and consistent dispute resolution. However, to satisfy that purpose, the submitted claims should share a sufficient link between themselves, as Ebeclat versus Argentina Tribunal stated. And we submit that in the present case, such link is missing because claimants' claims are not connected in fact, and they are also based on a different legal basis.
But are they not connected in fact that the claims arise out of the same underlying acts by the respondent? I mean, is that not a common factual element that applies across the claimants?
Madam Arbitrator, indeed, all claimants suffered from the same measure, namely the blocking. All claimants' websites were blocked. However, we submit that it is not a sufficient element in the present case because, first of all, opposing counsel may rely to the Fana Corte versus Argentina case, versus Netherlands case, where also unrelated investors submitted their claims to arbitration because they suffered from because they all were subject from the same measure. However, in that case, their claims arise out from one and the same bilateral investment treaty, which is not the case in the present circumstances.
The treaties here are by all, I mean, there are no substantive differences between the treaties, are there?
No, Madam Arbitrator. The only difference lies within the preamble of these treaties. However, it is not our contention that the fact that the legal basis is different, this is the major factor here, because the major difference here lies within the factual circumstances of the present case. Because even though the same measure was imposed on claimants, all the other facts are indeed different, because all claimants made their investment in areas separately. They also employs their own model of operation and accordingly provides their own features for the Tyrian users. And they were also subject to 3 separate ordinances issued by Tyrian Communication Agency on different dates, namely 28th of February, 1st of March, and 2nd of March. And subsequently, even though claimants alleges the violation of the same standards, namely expropriation and FET standard, this tribunal would need to assess the compliance with this standard for each claimant separately, namely the frustration of legitimate expectations with respect to each particular claimant separately, as well as the compliance of the due process of law. And this meant that this tribunal would de facto have 3 separate investment disputes connected in one joint procedure. And since this contradicts to the very purpose of multi-party arbitration, multi-party arbitration should be declined. That concludes my arguments. Thank you for your attention.
Members of the tribunal, opposing counsel, good afternoon. My name is Veronika, and alongside with my co-counsel, Arslan Beknezliyev, we appear on behalf of Friendsluk, Whistler, and Speak Up, claimants in these proceedings. In the following 19 minutes, I will elaborate on the procedural issues of this case. Despite being a breakthrough in the development of respondents' modern technologies, our clients were deprived of their investments and millions of devoted users. Realizing that responsibility is inevitable, Respondent decided to leave the sinking ship by denunciation of fixed convention. What is more, now Respondent asks his tribunal to keep our clients quiet by asking provisional measures that prohibit public awareness about the case. And finally, Respondent asks his tribunal to separate 3 claimants in different 3 arbitrations. However, we are here to prevent this from happening. With this, mirroring the structure of opposing counsel, I have 3 submissions to make. First, that this tribunal should not grant provisional measures. Second, that this tribunal has jurisdiction over the case. And third and finally, that this case indeed can be examined on a multi-party basis. Moving on to my first submission, that deals with provisional measures. Here, we agree with the task proposed by opposing counsel, such as the existence of a protected right, and that the measures should be urgent, necessary, and proportionate. However, we disagree that this test is satisfied. And to demonstrate that provisional measures, they cannot be granted in the present case, I would like to analyze this test prong by prong. Starting from the first one, existence of a protected right. Here, opposing counsel skipped a very important step. This is the attribution of all activities mentioned in the case file, such as lobbying and publications of articles and procedural documents, to our clients. And the only fact that is proven by the record, this is the publication of our own request for arbitration. Here, I would like to refer to the same case as it was done by opposing counsel, the Bhatia Gulf versus Tanzania Tribunal. And in that very case, Tribunal expressly pointing out that it is not prohibited to publish your own procedural documents. So our client just validly exercised its right to speak publicly about the case and to inform the publicity about the pending dispute. So therefore, this publication cannot anyhow create prejudice or pressure respondent or aggravate the dispute. Members of the tribunal, even if we analyze the content of this request for arbitration, it does not anyhow jeopardize respondents' rights. This is simply the 5 pages document that contain the summary of the facts and just our position in the big lines, such as the equity standard was breached, and yes.
Well, this tribunal will be deciding whether or not there is a violation. Why is it that you need to tell the public?
Madam Arbitrator, it is our valid procedural right to speak about the case, and also we know that one of our clients is a public listed company and we have obligations to inform our shareholders about the pending case. And it is important to understand what is the threshold for granting provisional measures, because here we would like to refer to the Nova Group versus Romania Tribunal. And in that case, Tribunal also dealt with a similar issue of aggravation of the dispute. And Tribunal stated that provisional measures can be granted only under exceptional circumstances in case of, I quote, continuing events that cause impermissible infringement to respondents' procedural rights. Members of the Tribunal, publication of our own procedural document, only 5 pages document that is already in this case file and these members of the Tribunal are already familiar with, cannot anyhow create pressure or antagonize the parties or make the resolution of this dispute more difficult.
If I can stop you there, as I understand it, the situation in Tyria is quite volatile. And they're trying to take measures in order to, minimize those problems. I guess following up on the President's question, yes, you've only done the request for arbitration, although apparently there's been part of a witness statement that also made its way into the public. But I intend, since you're opposing this, I take it you're intending on publishing other materials, right? Why isn't this just a appropriate measure so as to, given that questions of security are involved?
Mr. Arbitrator, in the case file, we have the only fact that our clients published their request for arbitration, and there is no information whether our clients have an intention to publish other procedural documents. And here it is important to distinguish what kind of particular documents were published. To do this, I would like to refer to the same case as opposing counsel did, United Utilities versus Estonia Tribunal. It is true that in that case, provisional measures were granted, but here it is important to distinguish between procedural documents published in United Utilities and in our case. In United Utilities, claimants published their memorial just before a couple of days of submission of the deadline for submission of respondent's memorial. So in that case, Tribunal found that yes, aggravation took place because claimants published their memorial indeed to pressure respondent just before the deadline of submission their own documents. But in the present case, the situation is very different because our client published a mere information that is already in the public domain. So even if this tribunal order provisional measures, this will not change the situation because the media and the international human rights organizations, they are already discussing such a high-profile case, and it is not possible to stop the media from discussing it.
Councilor, I think the issue here, as I understand it, is the publication of a conversation that is the subject of the issues in dispute in this arbitration and will be part of the testimony that is presented before this tribunal, and that it was a one-sided publication of a conversation that took place that is an element to be considered by the tribunal. So it's not just the disclosure of your own request for arbitration, but really the disclosure of evidence that will ultimately be heard by the tribunal. What would be your response to that?
Madam Arbitrator, opposing counsel also cited publications on page 37 of the record, and also response, allegedly that our clients, their response to the request for arbitration. However, page 37 of the record is respondent's own procedural documents, so it is not proven by the uncontested facts of the case. So therefore, for granting provisional measures, we should look what is proven by the facts of the case. For example, this was the only the absence of evidence was the only reason for denying granting provisional measures in the Karatuba versus Kazakhstan case. Because in that case, Kazakhstan could not prove that claimants organized lobbying and launched the websites with propaganda. It is interestingly to note that tribunal in that case even admitted that all the circumstances pointing out that it cannot be a mere coincidence, and it is very conspicuous the timing that these publications were done at the same time that arbitration took place. However, still there was no evidence proving that claimants did these activities. Provisional measures were not granted. Now, I would like to briefly address the other prongs of a test, namely such as necessity and proportionality. But before doing this, I would like to recall that this is the cumulative test, and that means that even one prong is not satisfied, provisional measures, they still cannot be granted. But still, if you look at the urgency, urgency means the impossibility to wait the issuance of an arbitral award. However, still there is indeed no such urgency because the information of the summary of the facts that was published in request for arbitration is already in the public domain. It is impossible simply to wipe it off. So therefore, since the necessary requirements for provisional measures are not satisfied, we kindly ask this tribunal to avoid granting them. Now, in the interest of the time, I would like to move to my second submission that deals with the issue of denunciation. Here, respondents' interpretation of Articles 71 and 72 suggests that the door for exit arbitration was closed for our clients. However, we submit that our clients still could access exit arbitration through the 6 months window left open for them by Article 71 of the Exit Convention. Here, opposing counsel conveniently turned the blind eye on Article 71 that is clear on its face, that denunciation takes effect only 6 months after the receipt of such notice. And members of the tribunal, it logically to conclude that investors, they are free to submit the dispute in this 6 months window, because from legal point of view, state still remains a contracting party to the convention. What is most important here, that our approach is confirmed by the overwhelming majority of case practice in the light of a denunciation of the Exit Convention by Venezuela. Here, we would like to make reference to such cases as the Blue Bank, Transbank, and Daniclin tribunals that analyzed the same legal issue at stake, and they all came to the conclusion that indeed investors they can submit their dispute in the 6 months window. If we pass our interpretation through the filter of public international law, the outcome will be the same. Article 70.2 of SLT does not provide for automatic denunciation of a treaty. It rather states that denunciation takes effect only after a specific period of time that is provided in the treaty. And in our case, this is 6 months period. Opposing counsel relied on one single case in its support, the Fabrica versus Venezuela. However, members of the tribunal, this case should not be taken into account in these proceedings. The thing is that Favianca tribunal, first, it goes against the overwhelming majority of all other cases, and it sparked huge criticism. Second, there exists the factual difference in the Favianca and in the present case, because in the Favianca cause of action appeared only 2 years before denunciation took place. But in the present case, the websites were blocked after denunciation. So therefore, there exists significant difference in the factual background. And finally, now, Favianca versus Venezuela facing the annulment proceedings on this very basis that this interpretation of Article 71 and 72 goes against the overwhelming majority. Now, I would like to go to...
And in another annulment case, in Vivendi versus Argentina, the annulment tribunal, in fact, observed the failure to exercise jurisdiction that exists is annullable. And what's your position on that here? If we fail to exercise jurisdiction that exists under 7172?
Madam Arbitrator would believe that if tribunal undertakes opposing counsel's approach, this will still can lead to the annulment proceedings in the present case. So therefore, this is also an important issue to take into account. Now, I would like to go to Article 70. I would like to make the point on the other remedies available to our clients. Because opposing counsel stated that exit arbitration is not available, and our clients can still go under additional facility rules. Here we disagree, because here the wording of this BAT is important. It states that additional facility rules, they are available only then the contracting state has not become a party to the exit convention. And that refers to the pre-exit period. And additional facility rules, they are not available after denunciation. To substantiate our position, we would like to refer to the case there with the very same wording. This is Venezuela U.S. versus Venezuela Tribunal. It also has such a wording, has not become a party to the exit convention. And tribunal there stated that has not become definitely refers to the pre-exit period. And if this wording referred to the present situation after denunciation, the wording will be the following, such as is party to the exit convention. So therefore, additional facility rules, they are definitely not available for our client. Also, opposing counsel concentrated on Article 72 and stated that there is a requirement of perfected consent before denunciation took place. However, members of the tribunal, here we disagree. This exactly legal issue at stake was analyzed by the Claimant versus Venezuela Tribunal, and tribunal came to the conclusion that investors, of course, they can accept state's offer to arbitrate within 6 months period. And Article 72 does not anyhow derogate from this general rule expressed in Article 71. So on this tribunal lacks jurisdiction over the case. Now I would like to move to my final submission that deals with the multi-party issue. Despite the respondent's desire...
Just to let you know, 15 minutes have passed, so you have another 4 minutes.
Yes, thank you. Members of the tribunal, here, despite respondent's desire to waste money and time on 3 separate proceedings, we ask this tribunal to follow a more reasonable approach and decide this case on a multi-party basis, in order to prove that all 3 claimants in the guest list of this arbitration, I have the following points to make. First, that there indeed exists sufficient link between investors, and second, that the fact that our clients brought a claim under 2 different BATs does not preclude this case from a multi-party proceedings. Opposing counsel stated that our clients are not connected and referred to the Abacoa Tribunal. But the standard proposed by the Abacoa Tribunal is the following, that there should be the same challenged state measures, their same rights and obligations that arise out of the BATs, and the relief sought. There's no requirement that the claimants should be absolutely identical. They just should be the same underlying facts of the case. So also opposing counsel tried to make artificial distinction between our clients by saying that they were blocked by 3 different ordinances. And to demonstrate why it's not, this argument should be irrelevant, please turn to the page 11 of record. So here on pages 11 and 12, pages 11 and 12, we can see 3 ordinances that blocked our client websites. Yes, of course, this is 3 different ordinances. But if we look, for example, on the line 375, we can see that they all were blocked under the same legal ground for the breach of Article 51b of the Law on the Media of Communications of the Republic of Korea. So the state's challenged measures, they are the same, and the simple fact that we have 3 other different ordinances, it does not anyhow distinguish free investors here. Also, opposing counsel referred to the legal differences in these cases, namely that we have 2 different BATs at stake, Tarina Vanda and Aliki-Athina BAT. But members of a tribunal, this fact does not anyhow preclude this arbitration from deciding this on a multi-party basis, because the same situation happened in the Flughafen versus Venezuela tribunal. Their tribunal applied without any problems 2 different BATs, Switzerland Venezuela and Chile Venezuela BAT. But even in that case, there were significant differences in the text of the BATs, because one BAT provided an applicable law clause, while other BAT was silent on this matter. And tribunal stated that yes, these differences exist, but still this does not preclude from examining this case on a multi-party basis. And yes.
And even if we were to decide that you couldn't bring this multi-party in one proceeding, would you just bring 2 proceedings, 1 under each bit?
Madam Arbitrator, here we respectfully disagree, because our clients, since they shared the same destiny, they were the only 3 social networks that were affected by the respondents' measures. Therefore, it is only reasonable on the considerations of procedural economy and on the risk of inconsistent awards in the future to decide this case in a single proceedings. So I see that my time is elapsing, and if there is no other questions, this concludes my argument. Thank you.
All right.
1 minute.
Oh, there's a rebuttal?
Yes. Madam President, Honorable Tribunal, 1.4 rebuttal. Opposing counsel misled the tribunal as to the legal test proposed in Abaclat versus Argentina case, because in that case, the tribunal stated that the most crucial fact was the collective nature of investment made, namely the bonds. And in the present case, we have 3 different social networks which promote their own model of operation, and accordingly they have their own model of compliance with the algorithms established by the new media law. And accordingly, the due process of law under the standards which were allegedly violated by our client would be assessed by this tribunal separately, and accordingly there is no sufficient link between the submitted claims, and this tribunal should decline the consideration of these claims in one joint proceedings. Thank you.
Members of the tribunal, it is true that in Abaclat versus Argentina, there were 60,000 of claimants that brought a dispute. However, if opposing counsel wants to hear another case that there were also 3 claimants, just in our case, this is the LJ versus Argentina. There are also 3 claimants brought a multi-party claim despite respondents' objections to this. Thank you.
Proceed to the merits? Or is there for
It's claimants.
claimants?
Good afternoon, Madam President, honored members of the tribunal. As I was earlier introduced by my co-counsel, my name is Arslanbek Niyazliyev. I represent claimants, that is Friendslook, Speak Up, and Whistler. When ethnic clashes occurred in Tyria, Respondent decided to amend its legal framework, requiring social networks to implement specific algorithms that will help control the content that could be posted online. Even though Tyria was seen as a state that welcomed foreign investment, it nevertheless blocked all social networks of our clients in pursuance of this objective. We submit that was done in violation of the provisions of BITs, and on this regard, we have 3 submissions to make. First, we submit that the introduction of the TCO ordinances that effectively block the claimant's websites amount to the expropriation of claimant's investment in violation of Article 6 of the BITs. Second, the respondent breached the principle of the fair and equitable treatment standard contained in Article 3, Subarticle 1 of the BITs. And third, we submit that the compensation that the claimants are seeking is not speculative in nature, and the discounted cash flow method provides an appropriate method of such quantification. We shall now turn to address our first argument. First, we'll demonstrate that there has been a substantial deprivation to establish expropriation and that this expropriation was unlawful. Governmental measures qualify as indirect expropriation if they substantially deprive the owner, in whole or significant part, of the use or reasonably to be expected economic benefit. And this was held in the CME versus Czech Republic case. Furthermore, the action, the measure, must be reversible. Therefore, we'll focus on 2 criteria here. That is the intensity and duration. In terms of intensity, we submit that as a result of blocking, claimants were deprived of their current revenues from advertising contracts and pay subscriptions that are to generate revenue once implemented. As a result, claimants had to wind down their operations and leave the Tarian market. Now, in terms of duration, we submit that the measure was permanent. Now, it might be a concern, and my colleague across the aisle may rely on the wording of the TCO ordinances, which we'll look into. We kindly invite the tribunal to look into page 11 of the record. If the tribunal is with me. On line 376, we see the wording pending further notice. That means that the measure is in force until further notice was given to the contrary. However, we submit that this wording is rather vague because the key difference between a temporary and a permanent blocking is the inclusion of a specified period of time. Or TCO ordinances do not even include a conditional blocking, that if the claimants developed an effective algorithm, they would be let in back to the Tarian market. Therefore, we submit that the measure was permanent. Now coming to the unlawfulness.
But, Counselor, just one follow-up question. I mean, you know basically your position that there has been a substantial deprivation with an element of permanence, but it's my understanding that the claimants' companies continue to operate globally, with the exception of this particular country. How does that fit into your position that there has been a substantial expropriation if they continue to operate with the majority of their assets and the majority of their operations in the rest of the world?
Madam Arbitrator, our focus is on the assets and the revenues inside Tariya, that is, inside the borders of the Tariya. That's why we submit that if the claimants' websites are blocked in Tariya, that amounted to expropriation of the claimants' investment. That the users cannot access in Tariya the website. Therefore, there's no traffic. Therefore, the claimants cannot show any ads or present their features. Therefore, we submit that is amounts to expropriation, since the claimants' businesses heavily rely on advertising contracts.
But have the claimants made, I'm sorry, have the claimants made any effort to repurpose the software that they're using or repurpose any of the assets that they contend have been substantially deprivated?
My question kind of went in that line. What has been expropriated? What's the investment, what's the asset that has actually been expropriated that you can't, you're seeking compensation for?
I'll first answer Mr. Arbitrator's question. Mr. Arbitrator, if we look into page 54, that is Article 1, it defines investments, and in Article 1, Subarticle A, point 4, we see rights in the fields of intellectual property, technical processes, and know-how. We submit that the claimant's investment is in under the intellectual property rights.
So you're saying what, the domain name? Or what was expropriated?
Mr. Arbitrator, also Subarticle 8.3 states title to money, and goodwill and other assets. That is also the part of the advertising contracts that are in there. Now, coming to Madam Arbitrator's question. If we look into page 61, paragraph 4 of Procedure Order number 2,
I don't know that we have page 61.
We don't have 61.
Page 61?
61.
Okay. Please proceed.
We see that after the blocking took place, paragraph 4, after the blocking took place, the claimants were knocking on the door, looking for assurances, looking for meetings, that this measure was in fact temporary or that this measure was reversible. However, claimants' efforts were in vain, and after 2 months were trying, the claimants left the Tyrian market. Does that answer?
Well, not necessarily. I mean, 2 months of trying to do what?
Madam Arbitrator, they were working still after the blocking took place. They were still working on the algorithm. However, they were trying to seek any sort of hope from the Tyrian authorities that this measure was temporary or any sign of hope by the Tyrian government. However, no hope was given. That's why it was the only rational decision that the claimants had, and that's why they left the Tyrian market.
So in your view, the deprivation was so significant that even though they could have reestablished later in time, it was taken. There was nothing left.
Madam Arbitrator, as observed by the tribunal in Benaholtes versus Egypt, a temporary seizure of an investor's hotel lasting for nearly a year was not ephemeral, but amounted to expropriation. In this present case, we see the same. The claimants' businesses were affected in terms of reputation, and they lost users in spite of the blocking.
So let me perhaps phrase it another way. Is there a duty to mitigate?
Could you please clarify what do you mean
So
by
if you're claiming damages for an expropriation, and presumably that do you have a duty to try to lessen those damages somehow by repurposing, for example, the algorithm that is the subject of the arbitration?
Madam Arbitrator, the claimants were in fact working on the algorithm. However, to complete the algorithm, they have to test the algorithm, and testing cannot occur if the websites are blocked. Now, coming to the unlawfulness, Article 6 of the BITs establishes criteria under which certain acts might qualify as lawful expropriation. It is our submission that certain criteria were not met by Tyria. First, respondents' measures were disproportionate, and second, respondents' measures were discriminatory. Now, the claimants do not dispute states have an inherent power to regulate within their jurisdiction. However, this right is not a carte blanche for a state to act as it may please. The measure in question must be proportionate. And observed by the tribunal in Peel Holdings versus Poland, the principle of proportionality requires a measure not to be excessive in relation to the purposes meant to be served. In the present case, the respondent state could achieve the same goal, which is to safeguard Tyria's public order, by introducing a less severe measure. And Article 9, page 9, Article 117, provides that there is in fact an option for a temporary blocking. And members of the tribunal, it would have the same effect as a permanent blocking, and is not a new practice. We've seen in other countries taking such measures. For example, in Sri Lanka, in spite of the bombings that took place in April of 2019, the government decided to block the social networks from 21st April to 30th April 2019. The bombings killed over 250 people. And we submit that the respondent state introduced the most severe measure, not taking into account the interests of the claimants.
What would be a more proportional measure?
Mr. Arbitrator, a more proportional measure would be a temporary blocking for a specific period, and if it will include in the law. However, in the TCO ordinances, no such period is shown, and that's why we submit the measure is permanent. Now, moving on with the second.
A state, I mean, the aspects of its sovereignty are the greatest when it comes to protecting its national security and its public from civil unrest. What's your response?
Madam President, we submit that after the blocking took place, there has been a general de-escalation in the larger cities. Therefore, it would be reasonable to unblock the claimants and give them the chance to develop and finish the algorithm if the measure is so temporary as they
Doesn't
claim.
that almost prove, in fact, that the measures were effective?
Madam Arbitrator, after the blocking took place, there was a clash on March 15th. However, after that, there wasn't, and because we submit that there were other measures taken by the respondent state, such as increase of police that have been observed. Now, claimant social, moving on with the second requirement, as observed by the tribunal in ADC versus Hungary, discrimination arises when one party, among several parties, engaged in the same business and under the same circumstances is afforded different treatment. Now, claimant social networks were not the only social networks operating within Taria. There were two other platforms, TruthSeeker and Wink. Radicals communities also used these two other platforms to disseminate hate speech. However, the claimants' platforms were blocked, and TruthSeeker and Wink were relatively given a free hand. Now, the responding counsel may allege as a reasonable justification why TruthSeeker and Wink were not blocked because TruthSeeker and Wink were less popular. However, we submit that this reasoning is rather false, and this inherently discriminates the claimants as being more popular. Now, in case of Wink, we have an explanation why it was not blocked, but we know from the facts that radicalist communities also used it, and it failed to develop an effective algorithm, and therefore we submit that Wink should have been blocked. And in case of TruthSeeker, we know from the facts of the case that it was 5 times less popular than FriendsLook, one of the claims, that FriendsLook exemplified the internet itself in Taria. And Taria has a population of 120 million, and 5 times less popular is still a significant amount of users. That's why we submit that the claimants were discriminated as foreign investors, and thus the respondent state violated Article 6 of the BITs.
Is the distinction between the size of the platforms, is that something valid that we could take into account as to whether or not that it's discriminatory or not, or do you think there's just makes no difference if they were that much smaller or not?
It is our position that this narrative is rather invalid because in times of crisis, it would be unreasonable to differentiate between social networks as they all present a threat. And that's what the respondent state has made. They made a distinction, and that was unreasonable and irrational. Now, coming to our second submission, that Taria violated the fair and equitable treatment standard contained in Article 3, Subarticle 1 of the BITs. And a key element of the fair and equitable treatment standard is a stable legal framework. We recognize that a state reserves its right to legislate, and by no means we put forward that predictable means frozen. However, as observed by the tribunal in Tota versus Lebanon, in the absence of a stabilization clause, regular changes would be considered as breaches if the change was drastic in the essential features of the investment.
Can I stop you there, because you're 14 minutes in, just by the way. The expectations of your clients have to be different going into Tyria that's just 2 years prior had come out of civil war. This is not a country that has a long history of stability, given the social unrest that came up, that flared up again. Should you have the same types of expectations that you're speaking of there, saying, well, they just changed the law? Well, different countries have different circumstances.
Mr. Arbitrator, your point of view is quite similar to the tribunal in Duke versus Energy, which stated that investors should take into account political circumstances surrounding the country. However, in the commentary of Professor Dolzer on this case in his article, Fair and Equitable Treatment Standard, Today's Contours, he stated that these type of frameworks are being set up to break the tradition, to break the past of history, and that's what we see here in the present case. The media law was set up to liberalize the internet and promote free speech. However, the requirements that have been set out that there are three requirements. That is, first, to develop an effective algorithm for all the social networks. Second, being that all social networks should provide the correspondence between the users. And third, that average users should provide their personal ID. We submit that this specifically third requirement is drastic and is too demanding, and it is contrary to the intentions of the framework, and observed by the tribunal Isa versus Spain, the intentions, the objective of the framework could give rise to legitimate expectations. And we substantiate that it is not only that, but the reduction of the deadline for the development of the algorithm from 60 days to 45 days and the subsequent blocking all cumulatively demonstrate that indeed TARIA failed to provide a stable legal framework. Now, coming to our third submission. First, discounted cash flow method is an appropriate method of quantification. Second, claimants' projections are reliable and reasonable. And to clear out the clouds of doubt, what the claimants are exactly asking for, we kindly invite the tribunal to page 17 of the record. If the tribunal is with me. What we see here is the profits of the claimants for the years of 2016 and 2017 and the projection for the year of 2018. And we have two methods at stake here. That is the discounted cash flow method proposed by expert and the method based on proven expenditure. However, the position of the respondent state implies that only cost of sunk investment should be compensated, ignoring future cash flow flows that an enterprise can generate. We submit that the appropriate method for quantification is discounted cash flow method. And yes.
Councilor, I'm sorry to interrupt you. Just one quick question on, just so I understand the numbers that you're putting forward. If you go to page 16 of the record, I understand that you're claiming for the claimant revenues projected through the end of 2018, but that costs are included only through the time of the blocking. Is that correct?
Indeed.
And shouldn't the projection include, if you're going to project revenues through the end of 2018, shouldn't you also include costs, projected costs through the end of that year?
Madam Chair, the claimants are not asking for the costs, and I represent the best interests of my clients, and that's what they ask for. We submit that discounted cash flow method is an appropriate method. According to the World Bank guidelines on the treatment of foreign direct investment, a condition to apply discounted cash flow method is for an enterprise to be a going concern. And to clarify, what is a going concern? A going concern is an enterprise that has been operating for a sufficient period of time to generate data for the future calculation of the income. And we submit that 2 years is indeed enough to establish track of profitability that would enable the claimants to more than double their revenue to 2018. And if we look into, for example, Instagram, in the year of 2017, Instagram generated a revenue of $3.67 billion US, and it doubled to in 2018, and in 2019 it is projected to more than double to $14 billion US. So when there's a success, when there's a popularity, it is reasonable to assume that the claimants would have been able to gain as much profit as we see here. As I see that my time has run out, this concludes my presentation. Thank you.
Respondent?
Thank
For
you.
merits, thank you.
Honorable Tribunal, esteemed opposing counsel, good afternoon. As introduced, my name is Nika Vartanova, and I will be addressing substantive issues of the dispute on behalf of Republic of Taria, respondent in the present proceedings. In the following 19 minutes, we will demonstrate that no violation of bilateral investment treaties concluded between Taria and Navanda and Taria-Kitoa is present because, first, no indirect expropriation happened in Taria regarding claimants' investments. Second, no violation of fair and equitable treatment could be found in the present case. And lastly, and in the alternative, should this tribunal find that there were breaches of bilateral investment treaties, we submit that no award of speculative amount of damages should be delivered by this tribunal under discounted cash flow method. Moving to the first argument. Claimants allege that there was a violation of Article 6 of the BATs due to the fact that blockings of claimants' websites amount to indirect expropriation and that this expropriation was unlawful,
and that respondent could not rely on police powers doctrine. To refute this argument, we will first prove that the blockings were indeed not permanent and were made so only due to claimant's own actions. Second, that even if the tribunal finds that there was substantial deprivation of claimant's investments due to actions of respondent, respondent acted in exercise of its state police powers and therefore should not pay compensation for blockings. Beginning with the first argument, indeed, claimants' counsel referred this tribunal to the fact that all three ordinances mentioned that they are pending further notice, and claimants relied on the fact that since there is no indication that these ordinances are temporary, they should be regarded as de facto permanent. However, we would like to disagree to this argument because under Article 117 of the Terrain Penal Code, there are three possible sanctions if the social network does not comply with the law, namely a fine, a temporary blocking, and a permanent blocking. And all three ordinances, mention that they are pending further notice, meaning that respondent could reverse them should the circumstances change. And circumstances in the present case were, members of the tribunal, that claimants did not comply with the law, they failed to implement the effective algorithm, and claimants could have relied on the fact that respondents slashed the term for compliance. However, not only claimants failed to implement the algorithm, but they willingly disregarded the requirement for collection of personal data of their users, and they decided not to block unverified accounts, and it was totally their own decision, which was not forced by action of respondent. And taking into account these circumstances, and furthermore, that although claimants rely on the paragraph 4 of Procedural Order number 3, which states that all negotiations were in vain with respondent, we would like to refer this tribunal to particular wording of this paragraph, namely to the page 61 of the record, to paragraph 4. And here the main word is that in the first line of the paragraph, seeing that any meetings with Syrian authorities and to seek assurances were in vain, claimants decided to put a temporary hold. End of quote. So the main word is seeing. This paragraph only implies that it was subjective understanding of claimants that there would be no negotiations with respondent regarding reversal of the blockings, and claimants failed to present any evidence that they actually made attempts to negotiate with respondent and to clarify whether these blockings are temporary or permanent and how they could reverse those blockings.
But so my understanding is that Truth Seeker and Wink were fined as opposed to blocked, correct?
Yes.
And so Truth Seeker and Find continue to operate today?
To our best knowledge, yes.
And are Truth Seeker and Wink being used to disseminate hate speech?
Madam Arbitrator, we are not aware of the most recent information. We only know that they were indeed used by radicalists, but not to the extent they were used through claimants' social networks, and they are currently under criminal proceedings regarding a fine imposition, so respondent is to impose an appropriate sanction on these social networks.
But why were then the claimants not fined? I mean, why were they blocked as opposed to fined if Truth Seeker and Wink are today continuing to operate, including through, providing a mechanism through which hate speech can be disseminated?
Madam Arbitrator, this brings me to the argument on discrimination, and to that we submit that there is no discrimination even when there is difference in treatment if there is a reasonable justification. And the reasonable justification in the present case is that the law provides that the algorithm should be effective for the scale of operations of particular social network and to the mode of operation. And to that we will argue not that the social networks interior were not as popular as claimant, but mainly that the reach of those social networks could not compare to reach of claimants. And second of all, that Wink and Truth Seeker have different mode of operation compared to claimant. First of all, Wink is a messenger which delivers messages from one user to another. Therefore, there is no reach to general audience, and it could not impose a threat on public order of respondent. And second, the Truth Seeker provides for opportunity to correct news and hate speech and to present a more objective picture of the circumstances inter alia, and therefore it also could not compare to the way claimants operate, because they provide for the feed where thousands of posts related to hate speech and fake news are posted every day.
Now, Truth Seeker was created by Respondent. Do you have control over any of the content?
Madam President, indeed, it was created by Respondent. We're not aware of particular peculiarities of the operation of this social network and how it correlates with Respondent, but we submit that it has more control over this social network compared to claimants, and this will only prove that Truth Seeker is different to claimants because Respondent can itself control dissemination of hate speech through this social network.
With respect to Wink, I understand that that allows for direct messaging between individuals. Isn't that almost more dangerous? That people can organize that direct messaging?
Mr. President,
I have not been promoted.
oh, Mr. Arbitrator, excuse me.
There
Claimants
was no coup.
Claimants could have relied on case of Telegram in Russia and say that it was blocked particularly due to the fact that it provided for possibility of delivering messages from one terrorist to another and in order to organize some clashes. However, to this we would submit that situation in Syria is utterly different. The problem in Syria is with ethnic conflicts between two main ethnicities, mainly the Tatar and the Manyar, and they are mostly induced to organize clashes through hate speech disseminated through claimant social networks. So there is no direct organization of these clashes. It is like unorganized events that stem due to the remaining conflict between ethnicities. Therefore, there is no higher danger imposed on public order of Respondent by Wink, which provides for messages, compared to general social networks which just disseminate hate speech through feeds. Therefore, on that premise, we submit that no discrimination could be found in actions of Respondent. And to clarify my line of argumentation, we first proved that the measures are not permanent, and in alternative, we're now proving that the conditions for police powers doctrine are satisfied by Respondent, and therefore no compensation should be paid for.
With respect to their not being permanent, are they going to be rescinded anytime soon?
Excuse me, could you
Are
clarify?
the measures going to be rescinded anytime soon, the ban?
Mr. Arbitrator, unfortunately no, because claimants left the country in the middle of April 2018, which is just a month and a half after the imposition of blockings, and as they decided to wind down their operation and did not comply with the law, although they initially said that 60 days period for compliance is enough for them, and they could perfectly well test their algorithms even if they were blocked, because testing does not require the access to the websites inter alia, as they already had a lot of examples of hate speech disseminated through their networks, so nothing impeded them from testing. We submit that Respondents should not be held liable for actions that could not be attributable to it.
And once they left, have you had any continued unrest?
Madam President, the only clash which was reported after blocking of claimants was on 15th of March 2018, and after that general de-escalation of conflict began, and therefore we submit that it only proves that measures were effective, which proves another requirement under police powers doctrine, namely proportionality. And moving to therefore, to conclude, we submit that no violation of Article 6 could be found by the tribunal in the present case, as a Respondent blocked claimants' websites in exercise of its regulatory powers. Now, moving forward to the second argument on liability of Respondent, namely on fair and equitable treatment standard, claimants rely on the fact that they imply that the regulatory framework which induces the investment implies that it will stay forever the same and no total changes of the law are possible. However, to that we submit that no general obligation of stability exists that could be derived from general laws in the country, and the only cases where tribunals held that regulatory framework could give rise to legitimate expectations of investors are cases when they are reiterated in specific commitments given by state officials towards investors. And for instance, in Masdar versus Spain, Next Era versus Spain, and Cube Infrastructure versus Spain, the latest decisions of fair and equitable treatment in 2018 and 2019, indeed, general regulatory framework was taken as providing for stability. However, the stability was reiterated in specific commitments, and furthermore, the general law provided for stabilization clause within it. And in one case, with the same circumstances as in Spain, where there were no specific commitments given to investors, namely in Sharan versus Spain, the tribunal completely disregarded the fact that the law was implemented specifically to induce foreign investments and that it provided the promise that the tariff will stay the same. In contrast, in our case, we are not aware of the particular content of the law which induced the investment. We only know that it generally liberalized the internet sphere and losing control over the media, and therefore we are not aware of any specific stabilization clauses included into this law. And the only representations given by respondent to claimants just provide for general promises that we will likely collaborate with claimants and this new law will lay down the ground for it. And as claimants do not even rely that these representations could be regarded by this tribunal as specific, we will also not believe that they could provide for legitimate expectations of investors, namely claimants.
Could the state's accession to the international agreements affording a right of public freedom of expression be taken as one of the objective demonstrations for the expectations?
Madam President, we do not contest that International Covenant on Civil and Political Rights could have been taken into account by claimants when they invested in Tyria. However, what Article 20 of the ICCPR states that the state is obliged to prohibit certain types of speech, namely which might incite animosity towards ethnic groups. And this is exactly in case at hand. And therefore we submit that no frustration of legitimate expectations of claimants towards human rights could be derived from actions of respondent. And to conclude the second submission on liability of respondent, we submit that no violation of fair and equitable treatment could be found in actions of respondent, as no legitimate expectations of claimants could be derived from general regulatory framework of Tyria or other statements of Tyrian officials. Moving forward to last argument of respondent on damages, in alternative, should the tribunal find that there was violation of Tyria Navanda and Tyria Kitoa BATs, we would invite the tribunal to disregard speculative calculations presented by claimant in their damages report. And to clarify our position to the tribunal, we contest all three heads of damages presented by expert in claimant's report, namely direct damages, lost profits for Tyria, and lost expansion profits. And to clarify why we contest direct damages is that due to blockings of claimant social networks in Tyria, claimants' physical offices and intellectual property rights in their websites remained totally intact. So they were not deprived of these assets at all. And therefore, direct damages to which claimants rely on in their damages report could not be awarded. Furthermore, the costs for marketing analysis and legal analysis of Tyrian legal framework also should not be included into direct damages, as they were already covered by profits in 2016 and 2017. Therefore, moving forward to lost profits claim of claimants, to which they applied discounted cash flow method. To that, we will argue that indeed discounted cash flow method is the most appropriate method of valuation of going concerns. However, as World Bank guidelines established, to which claimants counsel referred the tribunal to, there should be sufficient period of operation of the investor in the host state to generate objective data regarding investor profitability. And in the present case, we only have 2 years of operation presented in damages report. And for 2018, claimants claim profits which are double or even triple for some of the claimants, which sounds totally unreasonable given the following circumstances. First of all, most of the Taurian population has already had accounts on social networks of claimants. Therefore, we doubt that there might be increase in users of claimant social networks in Tauria, which might serve as a ground for increase in profits. Second of all, we submit that it is not totally certain that the new features that claimants were developing throughout 2017 will lead to such increase in profits, as the new features may not be popular. For instance, when Instagram introduced stories, it became a major success in this social network, as all of us use them sometime. And in Facebook, for instance, no one uses stories, the same feature that the social network provides. And therefore, we cannot agree with claimants that these new features will certainly contribute to the increase in profits. And therefore, based on this reason, we submit that discounted cash flow method should not be applied for calculation of lost profits. And finally, as to expansion profits, we do not contest just the application of discounted cash flow method, but what we contest is the existence of the mere causal link between actions of respondent and alleged damages due to expansion profits. Aliki and Larnaca are totally independent states that could decide for themselves whether to permit a social network or not. Therefore, when respondent blocked claimants' websites within Tauria, it could not have influenced the decision of Aliki and Larnaca, which could decide for themselves. And therefore, as there should be a proximate causal link between the actions of the respondent and the damages sought by claimants, we submit that the absence of such proximate link could not lead to the award of damages for expansion profits. And on that premise, I will conclude my submission and will respectfully ask this tribunal first to grant provisional measures requested by respondent in the proceedings. Second of all, to decline jurisdiction based on the fact that respondent denounced ICSID convention. And second of all, to decline this claim on multi-party basis, and on merits, first of all, to find that there is no liability pursuant to violation of bilateral investment treaties by respondent, and second of all, that even if there were breaches of bilateral investment treaties, no award of speculation damages should be delivered. Thank you.
If we were to decide that we don't have jurisdiction, that this can't proceed as a multi-party proceeding, you still contend we should grant interim measures?
Madam Arbitrator, if the tribunal decides that there is no jurisdiction over the merits of the case, the provisional measures would automatically fall to the tribunal. Yeah.
Thank you. Is there a rebuttal?
1 minute apiece, I believe.
We have 2 points in rebuttal. First, the respondent counsel stated that Wink had a different reach and therefore it was less dangerous. However, we submit that that is not true. We do not know from the facts that Wink what kind of reach it had. For example, in India, if we look into India, WhatsApp, a messenger application, according to the Wall Street Journal, presents a more threat than Facebook or Twitter because of its mechanism that prevents filter reaching spam messages. And we have the same instance in here with Wink. Second point, the respondent counsel alleged that the claimants have reached their limit in terms of their success. However, we submit that is not true because only 50% of Taurians have access to unobstructed internet, and there's a whole new market to exploit, and the claimants, by way of their new trending features, they could have exploited that market. Thank you.
And
Thank you.
rebuttal?
Members of the tribunal, we do not dispute that we are not aware of the reach of the Wink, since it is a messenger, so it's quite hard to calculate the reach of this particular messenger. And what we submit is that it has different mode of operation, which leads to different results regarding dissemination of hate speech. And as to the second point, we are not aware of how Council for Claimants made such calculation as to 15% of inhabitants interior having access to claimant social networks. But what we know from uncontested facts is that by 1st January 2018, almost every inhabitant of Teria over the age of 10 had an account on at least one of the social networks accessible in Teria. And this concludes our submission that there was no discrimination.
Thank you. Any other questions, members of the tribunal?
No?
No. All right, thank you very much.
Thank you.
Excellent presentations.
With that, we're going to let the tribunal withdraw to deliberate. I'd ask you to all please stay in the room here because we'll be starting the awards ceremony soon. The two teams, you can have a seat and take a deep breath. Keep your fingers crossed.